All right, well, good afternoon. I am John Leo with Leo and Oginni Trial Lawyers, and I am a member of the HYLA Solo and Small Firm Committee for this year. And I am proud to be the moderator and the host of this presentation on etiquette. And I'd like now to introduce our panelist, the Honorable Judge Raúl Rodriguez. And let me just tell you a little bit about him. So first of all, I think we're very lucky to have him here today. I've personally practiced in his courtroom. I've met him on many occasions. And I think his demeanor and his experiences in the past and the things that he's passionate for, like judicial temperament, are going to be absolutely valuable in the insights that he gives today. So Judge Rodriguez is a graduate of South Texas College of Law. I'm not going to say what year that graduation occurred. But he's had an esteemed private practice. He was in practice for about 26 years before he became a judge. He practiced primarily criminal defense. He worked on the referred cases from the court that he got, the appointed cases. He did, in addition to criminal defense, he also did some family cases and some personal injury cases. So he's got a wide variety of experiences, not just in the criminal law realm, but also in the civil side and the family side. So he's got a large amount of experience. He's also a mediator. He was referred cases from the family district courts and the civil district courts. So again, his exposure to the law, to etiquette, to seeing the good and the bad is just really, really enormous and vast. And that's part of the reason we're so lucky to have him here today. Judge Rodriguez was elected to the Harris County Criminal Court at Law number 13 in 2018, where he's been on the bench since. And I understand up for re-election again soon. So we hope that that all of you are able to go out and support Judge Rodriguez and continue his tenure on the bench. So with that, Judge, you care to have any opening remarks before we begin?
Sure. Well, John, thank you very much. I appreciate the opportunity for you to invite me to this webinar. And of course, I also like to thank the HYLA, the Houston Young Lawyers Association, for this opportunity. Like John mentioned, my name is Raúl Rodriguez. I am the judge of Harris County Criminal Court at Law number 13. And I was elected in November of 2018 to serve a 4-year term. And the court that I preside over is a misdemeanor court. It is a criminal court, and we primarily do Class A and Class B misdemeanors. And there's a wide variety of misdemeanor cases that come before me, but it's primarily just Class A and Class B. And the most serious offenses that a person can be sentenced to jail time is up to 1 year in the county jail. And the court presides over trials and hearings and motions. I do get every once in a while some appeals from the Justice of the Peace Court. So there are some cases that are tried in the Justice of the Peace Court or municipal courts that if a person does not like the outcome, they can always appeal it, and it will be appealed to the County Criminal Court at Law courts. And in Harris County, which is where I preside, there are 16 Harris County Criminal Courts at Law that does the same thing that I do, and I'm on number 13. So I'm number 13 of 16 courts. So that's what we do and who I am, and so I'm ready to proceed, John, whenever you guys are.
Okay, perfect. So just to get a little bit of the admin side of it out of the way, for the course number for the CLE credit is located in the chat feature. So you can go there to find the course number. Additionally, if you have any questions that you want to ask of the judge, just feel free to put those in chat. And as they come in, I'll see those, and then that's how we'll ask. So just make sure everything runs through the chat, and I'll try to get those as best I can. So the first thing I want to start with is the purpose of this event. So this is about etiquette, and this is something that we're all taught about through law school and on into practice. But what I was really wanting to do here is to answer some of the questions that we either maybe have been afraid to ask, feel like we potentially should have known already and feel silly asking, and just get from a judge's perspective what it looks like as we, when we are attorneys, are moving about the court and the things that we're doing in the court, and how those movements and actions are perceived, and some of the good and the bad ramifications from those. So if you do have any questions that you'd like me to ask of the judge, again, along those lines, feel free to ask those. And whatever the case may be, no judgment whatsoever. I'm not going to say anybody's name or anything like that. I'll just ask the question, and this is your shot. Just, we've got a wonderful judge here that's very open and sharing. So this is definitely the person to ask those questions of, here during this meeting. So with this being about etiquette, Judge, the first thing I wanted to ask about was dress and appearance. So we'll start there. And within the context of both men and women, I have personally seen a few things like, and I don't know if it's the COVID per se, but where it seems like the expectation of the court of some courts has kind of reduced, where we'll see maybe a polo shirt under a coat, maybe without a tie, or with a shirt without a tie, maybe just a sport coat. Can you speak a little bit about that in your court and other judges you've spoken to about the dress and appearance both of men and women?
All right. Well, in terms of appearance, of course, I would prefer that an individual that approaches me or appears in court dress professionally. We do have relaxed, I guess, requirements now, whereby you do not necessarily have to wear a suit and tie, especially in the summertime. In the summertime, it gets very hot in Houston, and it's very difficult if you come to court wearing a suit and tie because it's very hot. So we have relaxed the requirements for men in terms of having to wear a suit and tie. I do prefer, though, that if you do come to court, that you have at least a coat on. You don't necessarily have to wear a tie. And I have seen some lawyers that come in with just a dress shirt or even a polo shirt. And I don't mind that they dress that way as long as you put a coat on. I do want you to appear professional. You are in a court of law. And when I first started practicing, that's one of the things that I was taught as a baby lawyer, is to make sure that you dress appropriately and professionally when you appear in court. And so I would like also for attorneys to dress appropriately and professionally. I'm not going to get on someone for wearing, for example, a polo shirt, as long as they have a jacket. In terms of blue jeans, you can wear blue jeans as long as they're, they look good, they don't have holes in them and things like that. Especially now, right now, the way the rodeo is, I've had a number of lawyers come in wearing their blue jeans and boots, and that's perfectly fine. I have no issue with that whatsoever. And they have either a shirt and coat on, and that's perfectly acceptable for me. So I have no issue, just as long as you look good, it's neat, and you dress professionally. That's all that I require. Now, as far as the females, I have no requirement whatsoever on how they dress, as long as they just also look professional. I don't require any female to wear a dress or not. I don't require, I don't necessarily don't mind if they wear pants or not, just as long as they dress professionally. And same thing with women. Sometimes if you dress and you wear a coat, you look good, but not necessarily. I don't require any females that have to have coats on. I know that there's a different style and fashion for females. Just as long as you look good, professional, and a good appearance, that's all that I really care about. Now, on my court, I also do Zoom. I do Zoom hearings, and people do come to court on Zoom. I have dockets where attorneys appear in Zoom, and I would like for the same thing for these lawyers to appear, appropriately. I've had on occasion a couple of times, I guess when Zoom first started, where lawyers were dressed, for example, in a T-shirt. In my opinion, that's not an appropriate type of dress. If they wear a polo, if they put on a jacket, they're fine. Or even sometimes if they wear just a dress shirt, as long as it looks, clean and professional, that's fine with me. Same thing with the females, as long as they look good and professional looking. I have no problem with what type of a dress or clothing that they wear. So on Zoom, same thing. And I've gotten to the point where I've seen a lot of the lawyers, when they do appear in Zoom, that they do wear a coat and tie, which is fine, because a lot of the attorneys are have the attitude that, hey, I'm appearing in court, even though it's a Zoom, I'm still appearing in court. So I want to dress appropriately. And so for those lawyers, I do appreciate the fact that they do recognize that they are appearing in court and that they dress appropriately. So in terms of my requirements, that's what I require. Now, every court is different. I do recall when I was practicing, I did have one judge that required a suit and tie, no exceptions. Back when I was practicing, there was a couple of courts that were relaxed on their dress on ties, especially in the summer, because it gets so hot, and some of the courts would allow a lawyer to appear without a tie. Well, this particular judge, you could not. You must wear a suit and tie, no matter what day of the week it is, what season, but that was his requirement. So every judge is different. So if you want to know how to dress, maybe you would go to that court or ask other colleagues, hey, is there a particular dress policy, or even some of the court personnel, the court coordinator. But most of my experience with my colleagues in county criminal court at law, we're a little bit relaxed. We don't necessarily require you to wear a suit and tie, but each court is different.
Okay, thank you for that, Judge. And I was going to ask you about that, about the propensities of other judges, and then potentially if it'd be in their local rules or where attorneys could find that information. So the next thing I want to shift to is when an attorney comes into your court and is, in your case, dealing with a prosecutor, whoever that may be, it's a chief or just one of the prosecutors, and when they get into not necessarily disputes, but there is sometimes things become impassioned and heated, and in dealing with opposing counsel as an attorney, how etiquette and proper court etiquette and demeanor, I guess, prevails in that. So in particular, say speaking over each other. I've personally seen that where everybody just wants to be heard and to be the loudest, and they're standing in front of a judge, actively trying to speak over each other in front of the judge, and then potentially just a disagreement of opinion and how opposing counsel should handle that in the middle of the courtroom with the court and everybody watching in front of the judge, and then finally about. I've personally seen where counsel will insult each other, sometimes overtly, sometimes covertly, but the effect that has on you, the judge, and the perception of that attorney and what's going on in that moment. And just if you could speak a little bit about that.
Sure. In terms of how you deal with your opposing counsel, for example, I do expect that every lawyer treat every person with respect, with dignity and respect. We are professionals. We're lawyers. Let's act like an attorney. Let's act like a professional that we are, and treat your opposing counsel with respect. Allow that opposing counsel to speak their mind and their point, and you'll have the opportunity to do the same. So when I was practicing, that's one of the things that I would do is I would always approach a prosecutor, and ask some questions, but I'll be respectful. I do not, try to raise my voice, and don't get angry and mad. And let's face it, we have opposing sides. We have a prosecutor that wants to prosecute a case in criminal court, and then we have a defense lawyer who's defending their client, and they're defending their client zealously. So we've got opposites, that are kind of bumping heads. And that's with every case. We're going to have every case. But as long as you are able to get your point across, as long as you do so in a professional manner, with respect, you'll be able to go ahead and have your point made regardless of which side that you're on. In terms of hearings, whenever I have a hearing or trial, yes, I do tell the lawyers, allow the other attorney to make their point, allow them to finish. You will get your opportunity, to have your point made, and I will give you that opportunity. So I do not want you to talk to each other. And there's an occasions where things kind of get heated. One lawyer may want to make a point and it gets a little heated, and the other lawyer may say, well, no, that's not true, that's incorrect, and it gets heated. So I would tell the lawyers, okay, calm down. Let's take a step back. Let's treat each other with respect. We're not here to fight, okay? We are in court, and it is a fight sometimes, but we're not here to physically fight. And I definitely do not tolerate any abuse, any abusive language. I definitely do not tolerate people calling other attorneys names. That is definitely uncalled for. I never did that when I was practicing. I never would call another attorney by a different name or anything like that, because it's totally uncalled for and unprofessional. We should be able to have thick enough skin to tolerate, any type of disagreement that we have. We're all going to have a disagreement. So let's act like attorneys. Let's tolerate it, and then just try to make your point across professionally and with dignity and with respect, and you'll be able to, get your way. Now, as far as a lawyer, I'm sorry, as far as a judge, I do have attorneys that come before me, and after a while, you get to know who these lawyers are. Like, for example, you, John, when you come before me, you've always treated the court with respect and dignity and are very respectful and professional. And so when I see you come in the courtroom, I say, oh, hey, John Leo, hey, how are you doing? I know your reputation. I know how you're going to act. I know how you're going to treat other lawyers or other prosecutors. So, I would not have any issue with you. But there are some lawyers that have come before me that have not been that way. And then when you walk into the courtroom, one of the first things that I'm going to look at or think of, oh, here comes this lawyer. I kind of know how he is, so I just got to kind of be watchful. And so you're gaining this reputation. You don't want to gain a reputation of being that person or that lawyer that is either disliked or argues or is not respectful. You don't want to have that type of reputation, because trust me, that follows you. And not only does it follow you, we as judges know who you are, and we talk to our colleagues, other judges. We are, every once in a while, some of my colleagues would say, hey, do you know this lawyer? Or do you know that lawyer? And or watch out for this lawyer, he's done this, or be careful with this lawyer, he's done this. So we talk amongst each other, the judges. And so we know who the lawyers are that are not, acting right or professional. So that way we can be on the lookout. So just please do your best to act professional and reasonable and respectful, and you'll be just fine.
Okay, thank you for that. And I'll ask you just another follow-on question. So I've personally been guilty of this at hearings and even at trial on objections, going back and forth with opposing counsel. And I've really worked on tempering this, is that to get that last word. So every time, the opposing counsel makes a point, I just have the need to say, Judge, may I be heard very quickly. So the question I wanted to ask is that necessary, or is that from the judge's perspective, just sort of maybe like a lack of professional etiquette or indicative of personality where, maybe not confident in what you've said previously? Is it even necessary? Is it something that you're just like, I wish you guys would just be quiet because I've already made my mind up? From your perspective, Judge, how do you see that?
Well, nobody knows their case better than the lawyer. For example, you, John, you represent your client. You know your case better than anybody else. And if there's a point that you would like to make before a judge, and you feel that it's necessary that you need to speak up or make a last point, I will allow you to do that. I'm not going to cut you off. I'm not going to, stop you. I'm going to go ahead and let you make your point. And so just to give you an example, so say, John, that you're there and you have a prosecutor that is arguing their case, and then you respond, and then the prosecutor responds, and then you would like to respond again. As long as it's not repetitive and that you're saying the same thing that you said a few minutes ago, I will allow you to make your argument. I mean, I want to hear everything that you have to say, and I will give you that opportunity. I'm not going to cut you off, okay? Because like I said, you know your case better than anybody else, and there's obviously a point that you want to make, and I will allow you to make that point. And if I believe if it comes up to where, okay, Mr. Leo, you're being repetitive, I get you, I understand where you're going, and I may just kind of say, okay, I've heard enough, I'm going to make a decision. But I will definitely give the lawyers the opportunity to make their point across.
Great, thank you for that. I appreciate that. So we're going to shift gears just a little bit now to the interaction between counsel and the judges. So I've had an experience where I've gone to different courts outside the county, and I say, "Good morning, Judge," or I'll address the judge as Judge instead of Your Honor. I've gotten some odd looks from certain counties before, almost so as, you know, that wasn't their common practice. In Harris County, it does seem common practice. So regarding etiquette, how do you prefer to be addressed? And then how should counsel best deal with their clients if they refer to a judge improperly? You know, not even out of malice, but sometimes they'll be very nervous and they'll say, "Oh, Your Majesty," instead of Your Honor, or something like that. You know, that's just silly. So what do you prefer? And then how would you recommend counsel deal with their clients in interacting and addressing the judge?
Well, of course, I would like to be addressed as judge. You know, that's fine. I don't have any issue with someone that's saying a judge may approach, or judge, I have to say this. That's perfectly fine. Okay. I do want to be addressed as a judge because, you know, it's a matter of respect. Now, I do the same thing with the lawyers. I will always address them by their last name. So, for example, John, I will say, "Mr. Leo, how are you? Mr. Davis, how are you? Mr. Johnson, how are you? Miss Johnson, how are you? Miss Smith, how are you?" So that's just a matter of respect to those individuals that come before me. Now, in terms of your clients, of course, when I was practicing, I would always tell my clients that if you're going to go before a judge and address the judge, always address the judge with "Yes, sir," "No, sir," "Yes, ma'am," "No, ma'am," or "Judge," "Yes, judge," "No, judge." That type of respect. It kind of drives me a little bit crazy whenever I have an individual that just say, "Yeah, okay," you know. That unfortunately, I think what happens is a lot of times that's kind of how they address or talk amongst their family or friends. But when you're before a court of law, it has to be respectful. And I say the same thing to litigants, the individuals that come before me, the accused. I always address them also by Mr. or Ms. I will never address them by their first name. Okay, I will treat them with respect, and I would appreciate, you know, that same respect towards me. Another thing that I will, of course, let people know is when you do come to court, if I see you, John, for example, I'll say, "Hey, good morning, Mr. Leo, how are you?" And of course, that's just something that I've always done, and I have no problem with you saying, "Hey, good morning, Judge, how are you?" I said, "Hey, good morning, Mr. Leo, how are you doing?" If you want to approach the bench, of course, be respectful and ask permission to approach. So you would say, "Judge, may I approach?" "Yes, you may." Okay, and that's just part of the etiquette of being in a courtroom. You have to be respectful of where you're at and be respectful of the position that a judge is. And I learned that when I was young. I learned that from my elder lawyers, and they would always tell me, "Be respectful to the judge. Yes, sir. No, sir. Always ask permission to approach." When you're in a hearing or trial, just to give you an idea, and you're sitting at a counsel table and you want to address the court, remember to always stand up if you're sitting down and make your point. If you're in trial and you want to make an objection, stand up and object. "Judge, I object," or "Objection, Judge." But stand up. That's one of the things that I've noticed sometimes from some of the young attorneys. I guess we get comfortable sometimes. We just get a little comfortable and we want to say something and we don't stand up. I was taught to always stand up if you're sitting down when you're addressing the court. I was always taught to ask for permission to approach the bench whenever you want to do that. So that's just a sign of respect. And so that's what I expect these lawyers to do whenever they come to this court.
And with that, I thought of a follow-on question, and there's something that I've seen. What is your opinion on that sort of half stand that people do? And I don't know if you can see me in the chair, but they'll address the judge and they just lift up a little bit and say, "Good morning, Judge," or they'll ask a question and then just remain, basically, pick their backside up about this far. Just what's your personal opinion on that and the opinion of other judges you've spoken to?
I personally don't have a problem with that. At least you did stand up. To me, that I consider that's to stand up when you're addressing court. So that's fine with me. I don't have a problem with that. Sometimes, when you're in the heat of battle, especially in trial, and something comes up and all of a sudden you have to make an objection real quick, you do that. That's perfectly acceptable. I don't have any issue with that whatsoever. And I haven't heard any from my other colleagues that also have a problem with that. I don't believe that they have a problem with that whatsoever. But when you sit down and not stand up, at least make an effort, then I kind of have a little issue with that.
Okay, gotcha. Okay, so my next question is about still with the counsel and judge interaction. So when counsel disagrees with a judge's ruling, whether it be in a hearing or to an objection in trial, as far as etiquette from counsel to judge, just, can you speak a little bit about some of the bad that you've seen and then the right way to deal with that, with regard to etiquette and, deference to the court from counsel?
Well, in terms of, say, decisions that I make before the bench, you're going to not please somebody. Somebody's not going to be happy with whatever ruling the judge makes, because the judge has to make a ruling that it's going to affect one side and it's going to be favorable to the other side. So you're not going to please everybody. So someone's not going to be happy with your ruling. But I expect that the lawyers just accept that ruling. When I was practicing, there was many a times when a judge would rule against me, and I would just say, "Thank you, Judge," and accept it. That's their ruling. There's no need for you to say, "Well, you're wrong," or "I can't believe it," or "That's not right." You just say, "Thank you," and move on. You have other remedies that you can use if you do not agree with a particular judge's ruling. There's other things that you could do. Let's say you have a hearing in court on a motion to suppress hearing, for example, in criminal court, and I rule against you. Well, accept it, but realize that you have possible remedies, possible appeals issue that you can, that you can move forward on. So look into that. I don't expect a lawyer to be happy with every ruling, but I do expect them to say, "Okay, yes, sir, thank you," and not, respond with, "You're wrong, I don't believe you," or "That's not right," or anything like that, because that is disrespectful. And of course, the other thing that you're going to do is you're not going to make the judge happy. So if I have a lawyer that is disgruntled because of the ruling that I make and makes it known that he's disgruntled, I'm going to remember that lawyer the next time. Okay, I'm going to remember, so that doesn't bode well, to a judge whenever you have an attorney that responds in that matter. So just accept it, move on. If you have appealable issue, follow up. There's a couple of cases that I've had where the opposing counsel or counsel was not happy and they appealed me. I don't take it personal, nothing personal. That's their right. They have every right to appeal any decisions that I make, and that's fine with me. And if they believe that they would like another court to review my decision, I'm fine with that. I don't have any issue whatsoever. I do not take it personal in any manner. So I expect that the lawyers do the same, you know, accept it and move on and appeal if you feel it's necessary.
And with regard to objections, so when you receive objections during court and let's say during trial, for example, and an attorney makes just a long speaking objection, or do you personally like, do you like that, dislike it? You know, do you just tell them we're not doing speaking objections, or do you like them to just cite rule numbers with nothing else and say, oh, judge, I object 403 and just leave it alone? Or do you expect like a rule number and a short statement? As far as the counsel's etiquette with regard to that part of procedure, what do you prefer and what have you seen others prefer?
Well, I personally would prefer that if you're going to make an objection, I would want you to make the objection and what is your legal objection that you're making. So let's say you're in trial and you hear somebody testifying and the attorney believes that that's hearsay. You stand up and say, judge, objection, hearsay. That's all I need to know. You don't necessarily need to provide me the rule, the hearsay rule, or whatever. You just go ahead and object. I know what you're saying because I've been practicing for quite a while. So I know exactly what you're talking about when you say hearsay. The only thing that I want to hear is what is your legal objection? Objection, relevance. Okay, I understand what you're saying. That's all you need to say. You don't need to cite the rule or the case law or anything like that. Objections, it's outside the scope. Okay, I will rule on it. You know, now if I need further clarification, I may ask you, Mr. Leo, what's your authority? You're objecting to this statement being made. What's your authority for that? What's your specific legal objection and your authority to that? I may say that. Every once in a while I've done that, but I pretty much know when you make an objection and it's a legal objection like hearsay or relevance, things like that, I know what you're talking about and I will usually just rule. So if anyone wants to make an objection, they start making a statement, that I definitely will stop them. If you make an objection, I just want to hear your objection and what is the legal objection that you're making so that I can rule on it.
And what's your opinion again about if somebody's maybe trying to project as though, you know, well, I'm the smartest in the room, I know the rules back and front, back and front, back and front, and I just say the number. So if I don't say hearsay, if I just say 801 or 803, or I just say a number out there, what's your opinion on that? Like, and does that attorney appear to be pompous or kind of peacock feathering, or done maybe to you know, I guess maybe irritate or, you know, whatever to the opposing counsel? Like, what's the perception on that?
Well, I don't have a problem with you saying, you know, objection to rule, you know, 102. But you have to remember that whenever you're either in a trial or a motion that's being recorded, it's on the record. You have to remember that you have to specifically say what that objection is because you're on the record. If you just say objection rule 101, you know, to rule 101, well, what you're doing is you're not specifically saying what is the objection, what are you objecting to? Because if later on you want to appeal and that record is made and that record goes up to the appellate court, all they have in the transcript is what you're saying that the objection to is. So they may not know what it is. So I would require you to specifically tell me, okay? You know, I know the rules too. Sometimes I would have to look them up. But if you're going to object, you tell me, instead of the rule, just tell me what the objection is, because this is on the record. And I want to make sure that the record is clean as to exactly what you're objecting to. So I would prefer that you tell me what it is. And if you want to cite the rule, that's fine. I have no issue whatsoever with you saying objection, judge, hearsay, under hearsay rule, you know, etc. That's fine with me.
Okay. And so sticking inside the courtroom now, so when attorneys come to the court and they're going to need to approach and speak to you with, with the prosecutor, or, in other courts with opposing counsel, where do you like them to wait? Do you like them to wait in the gallery, in the jury box, to stand along the side? And then do you prefer that they wait until they're called on because you're prioritizing what's going on? Or do they just need to speak up and say, Judge, may I approach?
Mm-hmm. We have in this court, in most courts, they usually will have a area where lawyers will line up. It's kind of like waiting in line for tickets to go before a ticket booth. So in my particular court, most of the lawyers line up on the side where the jury box is, and they just kind of get in line. And when I see them, I know what they want. They want to approach. And when I see a lawyer standing there next to the jury box and waiting, I know he wants to approach. And so if I see you, John, standing there, I say, Mr. Leo, would you like to approach? Yes. Or if I look up to you and you say, Judge, may I approach? Yes, you may. So I know exactly what's going on if you're standing in that line. Now, if you're on the other side and you're maybe sitting down or not there where traditionally the lawyers line up to approach, I may not know that you want to approach. And if I have other attorneys that are waiting and you're over here on the other side, you say, Judge, may I approach? No, you may not. You please get in line and I will take you, in order. I have other lawyers that are approaching. Now, I will say this because I do have my dockets. I do also Zoom, and I've been told from lawyers that they enjoy Zoom because it gives them an opportunity to go to one court and be in another court, or if you're in one county and you have another case in Harris County and you Zoom in, it's very convenient for them to do that, and that's fine with me. And there's some individuals that for whatever reason, they may have just one case and they don't want to take the time to come to court and park and things like that. They'll Zoom in from either their office or home. That's fine. I have no issue whatsoever. But I am going to take any lawyer that is in the courtroom physically, present in the courtroom first before I take anybody on Zoom, because they've taken the time out of their schedule to come to court, to park, to come up to the courtroom. So they've given their time to do that. So I'm going to call on them first. So I'm going to call on all the attorneys that are present in the courtroom first before I have anybody on Zoom that approach. But it's just kind of stand in line and trust me. I see you. I notice you. I know you want to approach, and I may just say, yes, sir. Mr. Leo, you want to approach? Yes, sir. Come on up.
Perfect. And I'll just reiterate now for those that joined just a touch after we started, the course number is in the chat feature. And if you have any questions for the judge that you've thought about along the way, feel free to enter those in the chat feature and we'll get to those before the conclusion of the presentation. So George, I want to shift gears just a little bit now to interaction with the court staff. So what I have seen in every different court, every set of court staff has their own sort of personality, if you will, like as a group. They work together, they sort of meld. As far as attorneys and interacting with court staff and the etiquette that goes with that, the respect, can you just speak a little bit about maybe some of the good you've seen, some of the bad you've seen, and then what you expect, how you expect attorneys to treat your court staff?
Well, I expect that the lawyers treat my court staff with the same respect that they would treat me, with dignity and respect. Do not raise your voice. Do not get upset, okay? Because my court staff, my court coordinator, court reporter, the probation officer, my CLO, the clerks that are there, the bailiffs, they all are an extension of the court. And if I see an attorney say arguing with a member of my staff, whether that be my coordinator, reporter, whoever, and I hear it, I'm going to call that lawyer out and I say, hey, is there a problem? What's going on? Is there something I can help you with? I've seen in the past, especially when I was practicing, I would see lawyers come up to, say, for example, clerks, and we ask them, something, or they're trying to do paperwork to do a plea and it's taken a long time. And I've seen some lawyers say, "Hey, what's going on? Are you doing your job or not?" You know, things like that. That is very rude. And if I hear any lawyer do that, I'm going to call you up on that. I'm going to say, "Approach. Is there a problem? What's going on?" You know, you're not going to treat any person on my staff that way. They're hardworking people. The people that I have do an excellent job. They know their roles and their job, and they do everything to the best of their ability. And I also tell my staff the same thing. I tell my staff, you treat everyone with the same respect that you expect them to treat you. And that includes everybody. That includes lawyers. That includes the accused, the defendants that are there. Everybody's going to be treated with the same respect that you expect them to treat you. So for sure, I want lawyers and other individuals to treat my staff respectfully. And if you don't, and I hear from it, I am not going to be happy. And once again, I'm going to remember you. You know, that's one of the things that we as judges, we remember those individuals that have been rude to our staff or they're not, you know, acting professionally. I will remember you. And if I see that attorney come again, I'm going to think, the first thing I'm going to think is, that lawyer is not very respectful or has been rude in the past. Okay, you don't want that reputation. Now, the other thing that I've learned too, and I did this when I was practicing, one of your best friends, if you are practicing, say in criminal courts, whether that be as a prosecutor or as a defense lawyer, one of your best friends that you can have in court is the clerk and the coordinator. Because if you are nice and friendly to them, if there's an issue that you may have in the future, trust me, if you treat them well and you need a favor, they're more apt to help you out. So that's one of your best friends that you can have in the court is the clerks and the coordinator, and of course, sometimes the CLO, the probation officers. So treat them well.
And I'll just very quickly take the opposite side of that. So, you know, we're all humans. We have good days, we have bad days. And let's say I, as an attorney, come in to your court and the coordinator is having an off day, or the clerk is having an off day, or whoever's having an off day, whoever it may be. And that person is rude to me. So with you know, along the lines of etiquette in the court, how do you expect an attorney to deal with that issue?
Well, of course, you're right. We all have bad days. And if someone treats someone bad, you know, you can do a couple of things. You may address it to me and say, "Judge, you know, I just want to let you know that this is what happened." And then I can maybe talk to the person that did that. Or how would you treat somebody that was kind of rude to you? Do you say, "Hey, I'm sorry you're having a bad day. Okay, it's okay. It'll be fine. I'll just brush it off. I know who you are, and I know that that's out of your character, and I know that that's just maybe one of those things, and I'll just come back and see you the next time." It just kind of depends. You know, you have to just use your own judgment as to how you would deal with that. But I would just say deal with it as you would any other individual that maybe you had that it treated you that way. Most of the lawyers that come to court, they get to know who the personnel is. They get to know who the people that work in that court and what their reputation is and whether they're nice and respectful and things like that. And so I think they'll be able to determine if someone is having a bad day. I think they'll know. Now, same thing with attorneys. I know attorneys, a lot of them that come before me, you know, on a daily basis. And every once in a while, I'll have an attorney that just maybe is having a bad day. And I could tell they're having a bad day. But I will say, "Hey, no worries. I understand. Things happen. You know, it's just one of those things. But if I know you and I know your reputation and I know that you're not exactly up to the best of your abilities that day, I would just say, okay, you're fine, you're good. I'll see you next time. I know who you are, and I know it's just one of those things, and it happens. And I have bad days too, you know. Every once in a while, I get frustrated on people that come before me and things like that, and I may snap a little bit. If I do and I feel bad, I will apologize to you. I'll say I'm sorry, you know. So you just kind of use your judgment and deal with it like you would any other individual that may act that way towards you.
Okay. Now shifting just a little bit to like a trial etiquette. One of the things that, I'm sure we all remember back from, the mock trial days in law school is you stand up and the first thing you say, if you're going to give your opening statement or something, is, may it please the court. So first of all, do you consider that to be necessary? Do you consider it to be something antiquated? Is it just part of the normal etiquette of the court? And then if you could also talk just a little bit about something else I've heard from more seasoned trial attorneys is they'll say, I'm going to keep doing a particular behavior until the judge tells me to stop. And then I'm going to do it one more time. So if you could talk just a little bit about those two things during trial that you may have seen, and is that proper etiquette? Is that expected? Is that rude, disrespectful? How do you see that?
Well, in terms of trial, I was taught that way, to be respectful. And it's a tradition whenever you address the court, may it please the court. So it's just kind of like a tradition. And if you do that, that's fine. If you don't do it, that's fine too. It's not necessary. It's not a requirement. It's just one of those traditional things that have been going on for many years. And I've been taught to when I was practicing, to make sure that I say that, may it please the court, whenever I address either the jury or the judge. In terms of an attorney saying, I'm going to either act rude, I'm going to continue to act rude until the judge says something, I guess it depends on what it is that you're doing. If I really do think that you're acting inappropriately, I will let you know when you act inappropriately, okay? And then if it happens again, I will remind you that you're acting inappropriately. And I will probably tell you if it happens again, sir, please do not do that again. Or I will just say something like, I expect you to be professional and act professionally. Something to that effect. I'm hoping that by saying that it comes across. Now, of course, there are some lawyers that are those types of lawyers that would say, for example, I'll just give an example, would try to object just to throw off the other side. I have had in the past where one particular attorney was doing their argument, either the closing or their opening. It's more the closing, and the other side would object, and not really objectionable, a legal objection, but they do it to throw the other side off a little bit from their train of thought. And that's kind of a little strategy. If they do so in a respectful manner, hey, that's strategy. I've done that before, and I've had it done to me, and I don't take it personal. It's a strategy, and you just kind of roll with the punches and keep going. As long as they're respectful, I don't have a problem with that. But yeah, just make sure that you be respectful. One of the things that I guess a lot of the young lawyers can learn is talk to other seasoned lawyers that have been around, that have tried cases, that have been especially successful, and ask them, what do you think? What should I do? Or what can I do? Or these lawyers say, well, these are the types of things that you should do while you were in trial, or don't do that. One of the things that kind of drives me a little bit crazy is at trial, if I see a lawyer sitting there and I see the other side make an argument and the lawyer rolls his eyes or does makes those types of gestures. I will definitely have that lawyer come up and I will tell them, do not make gestures, do not roll your eyes, do not have any type of gestures whatsoever whenever you hear something that you do not like. I want you to stay there and remain stoic, okay, and listen, and then you'll have your opportunity to respond. Now, sometimes also, I had this case just happen recently on someone that was in trial with the accused, the defense lawyer's client was making those facial expressions in front of a jury. And I went ahead and had the attorney approach and I said, Mr. So-and-so, will you please tell your client to refrain from making any type of movements or facial expressions that he's hearing that is not appropriate, and I do not want to see that again. And usually that does the trick. They usually will say, okay, yes, I understand. Okay, so I definitely will not, tolerate, that type of behavior.
So we did get one question in, and it's about advice that you may have for attorneys that become like very emotional or impassioned, or maybe have anxiety that that leads to to anger, passion, anxiety in the courtroom, and how maybe they should deal with that individually, and or how you from the bench, I guess, interact with those individuals.
Well, we're all emotional. We're human beings, okay? And then if you're very passionate about your case and you're representing your client, whether that be the state or defense, and you get something that you think was adverse to you, and or you think that it's wrong, I can't necessarily help how you feel or how you react. But one of the things that I try to teach individuals is that, hey, you are a lawyer, okay? You're going to have sometimes things that are going to go against what you're advocating for. And the best thing I can tell you is just deal with it and accept it. Now, I've had lawyers that do get a little bit emotional, okay? They get angry. It just depends on how much they take their anger. If they get really angry and start raising their voice and start yelling, I will stop them, okay? That's definitely not appropriate. If they get angry and just kind of like, start speaking a little bit loudly, okay, I understand, it happens. We get emotional, and sometimes when we get emotional, we start talking a little bit louder. But as long as you're not really disrespectful, I'm not going to say anything to you. I've had people that I've seen in court that are in trial that do begin to cry, for example. It's just an emotion. I mean, I can't necessarily tell you not to do that. If that's how you feel, I'm not going to stop you. As long as you're not disrupting the court and being disrespectful, I'm not going to say anything about it. But just, be cognizant of that. If you feel that you're the type of person that's going to get that emotional and you think it may be disruptive, maybe there's some things that you need to work on trying to help yourself not to be that way.
Okay, and so we're getting towards the end. I do want to ask this one last question. I'm telling myself just a little bit, and then feel free to speak on anything that that was on your mind, Judge. If there was anything I omitted, and for the participants, if you need to go, feel free. My question, Judge. So back in the day, I used to intern at the Harris County DA's office, and as an intern, I would sneak back through the tunnels and I would find the judge's elevator, and I'd take the judge's elevator up to the hallways behind the court. And as far as etiquette and what's accepted and not accepted, from your perspective as a judge, attorneys using those judges' elevators, the movement behind the court to transition from one court to the other, using the restrooms that are there in the back. Can you speak just a little bit about that and your opinion on it?
I personally don't have an issue with it because I used to do that, okay? when I was practicing. Just as long as you're respectful, you know, if you go and use the restroom, you know, make sure that you leave it clean and tidy. You know, don't leave it messy. If you're, for example, especially the DAs, if you're going to use the elevator, I don't have an issue with that whatsoever. I understand, you know, it's a little convenient for you to do that. So I personally do not have an issue. Now, if you're there, for example, prosecutor, and you want to use the elevator, you see a judge there, I would ask for permission. Judge, do you mind? Do you mind if I ride with you, whatever? I will never say no to you. I said, no, of course, of course. And that's just a sign of respect, because those elevators are meant for judges, and it's a security issue. You have to understand that this is a security issue. You know, the purpose that we have that is for security. We just don't want everybody to go out there and use those, you know, use the elevators or the restrooms, you know, kind of willy-nilly.
Okay, well, I appreciate that. Okay, so it looks like we're closing in on time. Judge, did you have anything else that in particular that you wanted to speak about that maybe we didn't cover that was on your mind, or anything from recent?
Well, one of the things that I just want to make sure that everyone understands is that as a lawyer, your most important thing that you have as an attorney is your reputation. It's extremely important that you have a good reputation, especially if you're going to be practicing in courts, you know, on a regular basis. You do not want to be that lawyer that has this reputation for example, being tardy, or showing up late, or not being prepared, you know, or being rude. You do not want to have that reputation, because trust me, that reputation is going to follow you. So you want to have the opportunity to have the best possible reputation that you can have when you practice in these courts, because that definitely will follow you. And if you have a good reputation, trust me, we as judges, we will know. If I see Mr. Leo come up, I'll say, he's got a great reputation. I'm not going to have any issue with him whatsoever. And that's the type of reputation that you want to have.
Awesome. I appreciate that so much, Judge. And so now we'll go ahead and close out the meeting. And Judge Rodriguez, I really appreciate your time. I was not disappointed, and still believe you are the absolute right person for this. I thank you for your candor and your honesty. That really goes a long way. You know, some people are very, you know, maybe tepid or hesitant with their words, and but I appreciate all of your candor, and I think all of our audience members do too. So with that,
John,
we will close
personally,
out the meeting.
I appreciate it also. Thank you very much, and thank you to HYLA for the opportunity to speak with y'all. Thank you.
Thank you so much, Judge.